If you elect the traffic school option as the means to handle your speeding ticket, you'll keep the points off your record, but you're also locking that speeding ticket onto your driving history for the next 75 years. Your grandkids, heck, your great-grandkids might be retired by the time this falls off your record. In the past 12 months, 13,000 speeding cases in Orange County have elected this traffic school option. I wonder how many of those people realized they were signing up for a 75-year contract. By contrast, if those 13,000 people would have contested their citations in court, even if everything went wrong and they got points and fines and everything, it only stays on their record 5 years, not 75. That's huge. This applies to all violations, not just speeding tickets. Statewide in 2024, 130,000 people elected the traffic school option. How many people each year don't get offered a job because they have an old ticket on their driving record? I'm Jeff Lauder, and in today's video, I'm going to explain how you can avoid this 75-year trap and why contesting your traffic ticket is the best possible option for you to choose. After that, we'll discuss the rules the officers must comply with in order for their speed measurement device results to be admissible in court. This will lead us into a conversation about how to contest your speeding ticket in court and some of the obstacles that you're going to face. As part of that conversation, I'll explain why I think it's best you hire me or another reputable traffic attorney to help fight the case. I provided a video timeline so you can skip ahead if you desire. And as always, I put links down in the description. Let's bust out an old trooper photo and get after it. When you get a speeding ticket in Florida, you essentially have 3 different options to handle it. You can pay it, you can go to traffic school to keep the points off your record, or you can contest it. People know that if they pay their citation, they're going to get points on their record. They go to traffic school thinking they're doing their record a favor. They don't realize they've added 70 years onto the length of time that ticket stays. This is based upon Florida's record retention laws, which are governed by the Department of Library and Information Services. The rule reads that if the clerk of courts offers a withhold of adjudication, that the driver's license office must maintain that infraction on the driving history for the next 75 years. This isn't limited to the traffic school option. The 75-year rule also applies to fix-it tickets, toll violations, and a few other programs offered by the clerk. But it does not apply if you pay a non-toll ticket or contest any ticket. Look at the speeding ticket disposition information from Orange County for the past 12 months. 15,000 people elected to pay their traffic tickets. 10,000 people elected to contest them. That's 25,000 people that have elected for the 5-year option. Of the 10,000 people that elected to contest their speeding tickets, 20% of those were dismissed. 70% got no points, and only 10% got points on their license. If you hire a lawyer to contest your traffic ticket, you're likely to get better results, and it's only going to stay on your record for 5 years. It seems like a win-win. I can't really find a solid argument not to hire an attorney. You either save money because your case is dismissed, or you paid a small fee in order to have the best chance of dismissal. Throughout my career as a state trooper, an Orange County deputy, and a criminal defense attorney, I've spent a lot of time in traffic court. It's really not that complicated, but I have to tell you, fighting a speeding ticket isn't really easy either. Many people get this totally wrong, and I've seen them walk into court and just tell the judge their side of the story. That's not how this works. The state has the burden of proving that you were speeding. To do this, the officer will present documents to the court showing that he's been trained in speed measurement, that his device was properly calibrated, and that on the date the citation was issued, that all the pre and post shifts were properly done. If the officer can't prove that he was trained and that his device was properly working on that day, the results of the speed measurement device should be excluded. You should win. So if you go to court and you ask to see the officer's training certificate that he's been trained in speed measuring devices and he's unable to produce it, that should be grounds to have your ticket dismissed. But I've seen several judges circumvent this rule by asking the officer several questions. How long have you been running radar for? Have you gone to the school? Have you ever testified to speed? If the officer answers all those questions properly, the judge may tell you to carry on, that they believe the burden's been met. So not only do you have to understand the inner workings of the speed law, you also have to understand courtroom procedure to know when to push back against the judge and when not to. If you're going to fight a speeding ticket, there's some things you need to know. If you've been trained as a lawyer, you probably just need to touch up on the Florida Rules of Traffic Court and Florida Administrative Code 15B that handles all the speed measurement devices. If you haven't been trained as a lawyer, you're going to have to do some additional research. You're going to have to review the Florida Rules of Traffic Court, Florida Administrative Code 15B, the Florida Rules of Evidence, Florida Rules of Criminal Procedure, Florida Rules of Judicial Procedure, common legal objections, and I suggest you consider requesting the following documents from the officer: radar calibration certificates, officer training records, daily test logs, and any maintenance records. If you walk into court without a battle plan, you're not there to fight the ticket. You're at the judge's mercy. Let's shift gears. A retired state trooper commented on one of my recent videos suggesting that my legal analysis of a statute was mistaken. I'd like to clear the air. The statute in question is Florida's newly modified license plate law that makes it a criminal act to attach a license plate cover to the car if it obscures the reading or recording of the license plate. The law was already on the books. They just amended it from an infraction to a criminal charge. The state of Florida is using license plate readers to track your vehicle's movements. If you have a license plate cover that stops the readers from working, the government can't track you. Of course they made it criminal. The good news is the case should be dismissed. There's a loophole that most officers and most attorneys aren't aware of. I discussed that loophole in this video here, where I reviewed most of the major law changes that came out in July. Hit it hard.